Welcome back to Lost Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. A few weeks ago, I published a multi-part series dealing with GPS searches initiated at the border and continuous surveillance within the United States. Now, in today's video, we're going to focus on a Fifth Circuit case that deals with a search of a cell phone at the border. We're also going to look at other circuits, how they ruled on this type of search. Before we go on, I think it might be beneficial for you to watch that series, or at least the part that deals with the overview of how border searches work, where I described routine versus non-routine searches and other aspects of border searches. Now, here, let's focus on the cell phones at the border. But before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button, sharing my channel with your friends and family. And if you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to loststash.com and checking out some of the merch, including hats and these Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lawstash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstash YouTube page. That's LAWSTACHE.
The Fourth Amendment protects you against unreasonable searches and seizures, and today we're going to address an intersection of two well-established by the Supreme Court precedents of the Fourth Amendment. On the one hand, the Supreme Court has long held that searches made at the border are reasonable simply by the virtue of the fact that they occur at the border, pursuant to a long-standing right of the sovereign to protect itself by stopping and examining persons and property crossing into this country. But on the other hand, the court has also made clear that searches of the modern devices like cell phones can be unusually intrusive. After all, cell phones differ in both the quantitative and qualitative sense from the other objects that might be kept on arrestee's person. Depending on the extent of the search, the government could theoretically access virtually every aspect about one's life based on a single handheld device. The facts of United States v. Castillo, a Fifth Circuit case from the summer of 2023, are pretty straightforward. Mr. Castillo was crossing into the United States in his RV. During the search of his vehicle, officers found a revolver, ammunition, and evidence of marijuana. He was detained, put in a holding cell, at which time he confessed and admitted to the revolver as being his contraband. And during that time, he also provided his password to his cell phone to the officers. The officers then proceeded to manually search through the apps on Mr. Castillo's phone. During that manual search, they found other evidence of other crimes on that cell phone. Mr. Castillo moved to suppress all the evidence found on the phone pursuant to the Fourth Amendment. He said that the Fourth Amendment protects against unreasonable searches and seizures, and searches done without a warrant are typically unreasonable under the Fourth Amendment. But there are, of course, exceptions to the rule. The border search exception is a long-standing, historically recognized exception to the Fourth Amendment's general principle that a warrant be obtained for a search. The border search exception allows officers to conduct routine inspections and searches of individuals or conveyances seeking to cross borders without any particular suspicion of wrongdoing. Moreover, even so-called non-routine searches need only reasonable suspicion, not the higher threshold of probable cause. For border searches, both routine and not, no case has required a warrant. The scope of the search conducted under the exception to the warrant requirement must be commensurate with its purposes. The border search exception reflects the long-standing right of the sovereign to protect itself by stopping and examining persons and property crossing into this country. The government's interest in preventing the entry of unwanted persons and effects is at its zenith at the international border and has been recognized since the beginning of our government. Historically, such broad powers have been necessary to prevent smuggling and to prevent prohibited articles from entry. So let me remind you of a few examples of border searches that I've previously discussed on this channel, and you can search for those videos in order to understand the full case. But let me quickly give you an overview. Of course, officers can inspect a traveler's visa before they enter the United States. They can also search the individual's luggage. There's also another case that allowed officers to search envelopes of mail, whether that mail was on the person or in that traveler's luggage. And finally, the Ninth Circuit case allowed officers to remove, disassemble, and reassemble a traveler's gas tank if that person was traveling in a vehicle. That is, of course, because officers can look inside and search for narcotics. Now, all of these examples are what are deemed routine searches. Those do not require any reasonable suspicion or warrants. But as you can tell, the examples I just gave you are different than a cell phone. As the Supreme Court in Riley correctly told us, modern cell phones are like microcomputers. The devices can hold vast amounts of information, including banking, medical, and other information that most people would like to keep private. So the Fifth Circuit joins the 11th and 9th Circuit in saying that manual searches of a cell phone are deemed routine and do not require reasonable suspicion or a warrant. But of course, we're dealing with only manual searches. Officers cannot look at encrypted information or deleted files. This is not a forensic search. Forensic searches might require a higher standard. But for only manual searches, like we have in this case, where the officers simply entered the password, opened up the phone, and looked through the apps, that is allowed without a warrant or reasonable suspicion because it is deemed a routine search. If you enjoyed this video, if you learned a little bit more about border searches and searches of a cell phone at the border, please give this video a thumbs up. Please subscribe to my channel, share it with your friends and family. And if you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support my channel, please consider going to loststash.com and checking out some of the merch, including these Do Not Arrest This Person t-shirts, hats, and other items. And if you're still listening to this video, consider going and watching that multi-part series dealing with GPS searches initiated at the border and continuous surveillance within the United States. It is a related series to this video, and I think you might enjoy it. Thanks for watching.